What exactly is the burden of proof in a criminal case? Hi, I'm attorney David Aylor, and I'd like to briefly explain to you the burden of proof in a criminal case. In a criminal case, the burden of proof always falls on the hands of the government. The government himself has to prove any and all allegations against the defendant. The defendant is always, under any circumstances, presumed innocent until found guilty. For an individual to be found guilty in a criminal court, it has to be shown beyond a reasonable doubt to a jury that he or she is guilty of what has been alleged. The defendant himself or herself has to prove absolutely nothing in defense. It is only the government that must prove any actions they allege beyond a reasonable doubt in front of a jury or a judge. One example I'd like to briefly explain is when one is charged with burglary. In that situation, if the government charges an individual with burglarizing a home or a business, it's not up to that individual to prove that they weren't there or that they in fact did not burglarize the home or business. It is the government's job and it is their duty to prove that that person, beyond a reasonable doubt, actually did commit the burglary. The defendant himself or herself does not have to show where they were, whether or not they were there at all, or why they were there if in fact they were there. It is up to the government to prove that they in fact committed that crime. If the defense chooses not to, they don't have to put up any defense on behalf of the defendant himself or herself. It is up to the government to prove the allegations. For more questions related to criminal law as well as civil law, you can always contact me at my office at 577-5530 or on the web at www.davidaylor.com. Thanks for watching.